Ladies and gentlemen, if we can come to order. Emmanuel, the floor is yours.
To our esteemed panelists, alumni, and all of our invited guests, welcome to the University of Georgia School of Law. My name is Emmanuel Ozzie, and I'm the president of the Black Law Students Association here at the university. We are delighted to have you all here today to participate and share in the reenactment of the case which led to the desegregation of Georgia 50 years ago. The program today is part of a university-wide celebration of courage, particularly the courage of Mr. Hamilton Holmes and Mrs. Charlene Hunter, who bravely marched onto UGA's unwelcoming campus on January 10th, 1961. That courage lives on today as we students, faculty, and staff continue to foster an environment that is welcoming to all. We are honored to have with us today two of the law school's first African-American graduates, Justice Robert Benham, who graduated in 1970, and attorney Kenneth Dyess, who graduated in 1973. Also with us today is Judge Ward. Now, Judge Ward was the first African-American who attempted to attend the University of Georgia in the 1950s. And although he was unsuccessful then, he would ironically come back and litigate this particular case after graduating from Northwestern. The program today was designed to educate, inspire, and entertain. And I'm confident that we'll be able to achieve at least one of those today because the program was directed by Professor Carlson. Now, Professor Carlson has previously directed 4 trial reenactments, commencing with Midnight in the Garden of Good and Evil, which occurred in the 1990s. He's the author of 14 books on evidence and trial practice, and he comments frequently on WSB. Professor Carlson received his JD from Northwestern University and a Master's of Laws from Georgetown. Once again, on behalf of the Black Law Students Association, welcome to the University of Georgia School of Law. And now, Professor Carlson.
Oh, thank you for those great words. Emmanuel, I appreciate that gracious introduction, and I appreciate our audience being here. It's wonderful to see so many here this afternoon. Ladies and gentlemen, let's take our mindset back to 1960. Now, for a lot of teenagers in America at that time, it was a time of malt shops and sock hops and Elvis. But for others, it was a time of closed doors and restricted access to education. What was going on in America at that time? Leading up to 1960, we had Governor Faubus in Arkansas. He refused to allow the integration of Central High School, and that triggered a standoff with President Eisenhower, which the president won when he sent federal troops to Little Rock to enforce integration. And what was going on at Georgia around this time? Well, the forces of segregation were initially aroused when the case of Horace Ward versus University Board of Regents went to court. Judge Ward, denied admission to Georgia, wound up enrolling at Northwestern University in Chicago. Professor Robert Pratt tells us, and I quote, "Ward remembers his classroom experiences at Northwestern as being positive. He studied diligently not only out of a desire to succeed in his chosen profession, but also because he felt the added burden of having to prove himself, because university officials here said he did not possess the qualifications to be a lawyer." Pratt concludes, he, Horace Ward, was determined to prove them wrong. Now, Judge Ward's journey through Chicago and Northwestern came full circle back to the University of Georgia in 1960, the period we're going to revisit today, when he joined into the case of 2 remarkable students, Hamilton Holmes and Charlene Hunter. They were superstars, Judge Ward was quoted as saying in the brilliant 2011 report by Robin McDonald in the Fulton Daily Report, reporting on this period. Onto what sort of landscape here in Athens would these superstars land? Well, one writer remarked to Dean William Tate as follows, saying, "You, Dean Tate, were the last person whom I would have expected to graciously present the university to the Negroes. I'm sure your Confederate grandfather would have turned over in his grave had he known of the open arms with which you welcomed them." Now, happily, there were voices on the other side, with one person declaring, "The rock-throwing wolves of hate have damaged this state tremendously. It will take time to erase their ugly marks." And I'm indebted to my colleague Tom Eaton, who called to my attention these letters, which are presently on display in the foyer at Russell Library. Turmoil, to say the least, folks, was in the air. Now, like many of the great desegregation cases of that era, this one, the case of Hunter and Holmes, would be tried in a federal court. It was the federal courts of the South where justice would have to be handed out, if it was to be handed out at all, federal judges with their lifetime appointments, federal judges who did not have to stand for re-election in front of voters like the one who told Dean Tate about his Confederate grandfather. My favorite line from a court decision of this period comes from John Minor Wisdom. He wrote, "A person should be able to find an education by taking a broad highway. He should not have to take byroads through the woods and follow winding trails through sharp thickets, in constant tension because of pitfalls and traps, and after maybe years of effort, perhaps attain the threshold of his goal when he is past caring about it." The Holmes and Hunter legal team had filed pleadings which claimed the two students had been wrongfully denied admission when the state said there was lack of space for them in one case, and in the other case, that the candidate for admission was evasive. To break through these excuses, evidence would be needed. Now, in that great old-time radio show that I remember well, The Lone Ranger, Brace Beamer, the announcer, would urge us every week, "Return with us now to the thrilling days of yesteryear." Well, folks, in similar fashion, let's return to the thrilling day in 1960 when students Hunter and Holmes entered the federal courtroom in Athens, Georgia, of Judge William Boodle.
All rise. United States District Court for the Middle District of Georgia, Athens Division is now in session. Judge William Boodle presiding. All those hearing business before this court, draw nigh and give their attention.
Be seated, please. It appears the next case on my docket is the case of Charlene Hunter and Hamilton Holmes to gain admission to the university. Mr. Marshall, will you please tell the plaintiffs to come into the courtroom? I think we're ready to begin. Ready for the plaintiffs?
Ready for the plaintiffs, Your Honor.
Ready for the state?
The state is ready, Your Honor.
All right. Counsel for the plaintiffs, do you have a witness ready to be called?
Yes, Your Honor. At this time, we'd like to call Mr. Hamilton E. Holmes to the stand.
Okay, Mr. Holmes, step up to the witness stand, face the court, and raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth in this case now and hearing this, so say I do.
I do.
Be seated, please.
Mr. Holmes, will you state your full name for the record, sir?
Hamilton Earl Holmes.
Now, Mr. Holmes, are you a resident of the state of Georgia?
Yes, I am.
And did you attend high school here, Mr. Holmes?
Yes, I attended Turner High School in Atlanta.
Now, while at Turner, did you receive any sort of awards?
I was voted best all-around student.
Anything else?
Well, I was also co-captain of the football team and senior class president.
Any academic awards, sir?
Objection, Your Honor. Are we really going to follow this man's history all the way back to the senior prom? Character evidence is improper in civil trials and should not be allowed.
Well, counsel for the state, I don't think the plaintiff's attorneys have invaded character so far. Their background questions are proper. Objection overruled.
Thank you, Your Honor. Now, Mr. Holmes, did you receive any sort of academic honors, sir?
Yes, I was valedictorian of my high school graduating class, and after that I applied to the University of Georgia.
Now, applying to the University of Georgia, do you recall an interview with any admissions officials from the university, sir?
Yes.
And did they ever ask you if you were arrested, sir?
Yes, they did ask me that question.
And how did you respond?
I told them I had never been arrested.
Were you in fact arrested, sir?
No, I have never been arrested.
Now, during the course of that same interview, Mr. Holmes, do you recall being asked whether or not you frequented red light districts, sir?
Yes, they did ask me that question about red light districts, and I told them I had not.
And have you ever attended houses of prostitution, Mr. Holmes?
No, they asked me that question too. I assured them, no houses of prostitution.
Did they ask you about interracial parties, sir?
Yes, they asked me if I went to any interracial social functions. I told them I had not, but I did attend interracial debates. I attended these with Agnes Scott and Georgia Tech students.
Now, Mr. Holmes, why did you apply to the University of Georgia, sir?
Well, I spoke to my father about the matter, and we both decided that I should attend the best school in the area.
And why do you want to attend the University of Georgia, sir?
Well, the University of Georgia has a pre-med program, and once I graduate from that, I can go to the Medical College of Georgia.
So, what course of study do you intend to pursue at the University of Georgia?
Pre-med.
Do you have any doctors in your family, sir?
Yes, my grandfather is a physician and a surgeon.
And did he encourage you to come here to the University of Georgia?
Yes, his name is Hamilton Mayo Holmes, and he taught me to fear nothing because he always said that the Lord will watch over you and you will have nothing to fear.
Now, Mr. Holmes, do you recall receiving any sort of notification about the denial of your admission, sir?
Yes, I actually have the letter right here. I could read it for you if you like.
Oh, well, what does it say, Mr. Holmes?
It says, from a review of your record and on the basis of your personal interview, we are hereby of the opinion that you do not qualify as a suitable applicant to the University of Georgia, and you are hereby denied admission. We regret that we are unable to accommodate you in your request. This is signed by the Registrar of the University of Georgia.
And what other reasons, if any, did they give you for the denial of your admission, Mr. Holmes?
Well, I did hear from one admissions counselor that I was evasive.
Did you say evasive?
Yes, Your Honor, evasive.
Really? You know, that was the same thing they told me. Your Honor, at this time, the plaintiff has no further questions.
All right, I have one question to the witness before we pass him for cross-examination. Mr. Witness, I heard you mention that they'd asked you during the interviews about houses of prostitution, red light districts. Did they ask you any other questions?
Yes, Your Honor, the interview actually had something to do with football.
They asked you about football?
Yes, Your Honor. The interview was about an hour, and about a third of the questioning was about football.
About 20 minutes on football.
Yes.
Okay, thank you. Any cross?
Mr. Holmes, you say that you applied to the university in July of 1959. Is that right?
That is correct.
Now, prior to filing this application, did you speak with any officials at the University of Georgia?
No, I went up to the university to obtain the application, but I did not speak to any officials.
Did anybody accompany you to get this application?
Yes, my minister and Ms. Charlene Hunter.
Did you send the application?
No, I didn't. I gave the application to my high school principal, and according to this receipt stamp, they received it on July 22nd, 1959.
And of course, you got an answer to that application.
Yes, they rejected me.
And after you were rejected from the university, you also received a letter from the registrar stating that you would not be attending UGA. Is that correct?
That is correct.
Now, after you got the application and after you got the letter from the registrar, you decided to enter the Negro College, Morehouse. Is that correct?
That is correct.
Now, when you were at the Negro College, is that when you decided to contact these attorneys?
Yes.
Mr. Holmes, when did you hire these attorneys?
Well, let me be clear. I did not hire these attorneys. My parents did.
Did you tell these attorneys to file suit?
Well, I told my parents that I seriously wanted to attend the University of Georgia.
Did you approve this lawsuit?
When I spoke to the attorneys, I told them to do whatever was necessary.
Now, while all of this is going on, you also filed an appeal to the president of the University of Georgia, did you not?
Yes, I did.
And from the president to the chancellor?
Yes.
And from the chancellor to the Board of Regents?
Yes.
And all of this resulted in you receiving an interview, isn't that correct?
Yes, I finally received my interview.
Now, prior to this interview, did you speak with Miss Charlene Hunter?
No, I did not.
Did you speak with your attorneys?
Yes, I did.
And what did you and your attorneys discuss?
Objection, Your Honor. Opposing counsel knows that the scope of our conversation is protected by attorney-client privilege.
Any questions in aid of your objection, counsel?
Yes, Your Honor. Permission to ask one question in furtherance
I'll
of the
permit a
objection.
brief voir dire, but keep it short.
Thank
Go
you.
ahead.
Now, Mr. Holmes, what did your attorneys tell you to do?
Well, they really didn't tell me much. They just told me to tell the truth.
Thank you, Mr. Holmes.
Okay, State, complete your cross-examination.
Yes, Your Honor. You say that you were persuaded to apply to the University of Georgia by your father and your grandfather so that you could pursue a career in medicine. Mr. Holmes, isn't it true that you were persuaded to file this suit by outside groups? Isn't it true that you were recruited by the NAACP to integrate the University of Georgia?
Objection, Your Honor. Counsel is speculating outside the record.
Your Honor, if I may, I can answer the question.
Well, go ahead, Mr. Holmes. Yeah.
Thank you. I wasn't drafted by the NAACP. In football terms, I was a walk-on.
I have nothing further for this witness, Your Honor.
Thank you, Mr. Holmes. You may step down.
Thank you.
Counsel for the plaintiffs, next witness, please.
Your Honor, the plaintiff calls its next witness, Ms. Charlene Hunter.
Ms. Hunter, come up, face the court, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this case now and hearing? If so, say I do.
I do.
Be seated.
Will you state your name, please?
Charlene Hunter.
Just a little bit louder, please, Ms. Hunter. Where do you live?
I live at 1504 Mosley Place, Atlanta, Georgia.
Ms. Hunter, did you come to the city of Athens for an interview in December of 1959?
Yes, I came in order to have an interview with the UGA registrar.
Now, did you actually see the registrar, and how long were you there?
Yes, I saw him, but our conversation was not for very long.
Now, at that time, the registrar informed you that he could not conduct an interview, correct?
Yes,
Ms. Hunter, did you or did you not have the occasion of coming back to Athens again this past month?
yes, I did.
And what were the purposes of your coming at that time?
Well, that time was specifically for the interview.
Now, when you say specifically for the interview, what exactly do you mean?
I had received a letter from the Board of Regents stating that there was one last step in the application process for me to complete, which was the interview. So I wrote back requesting an interview.
So when did you go to Athens?
On November 5th,
When you arrived, did you immediately go into the registrar's office or did you have to wait?
I waited.
While you were waiting, did you see any other persons coming in and going out the office?
Yes, there were a number of prospective students going in and out of the office for their interviews.
And about how long were they in there?
About 7 to 10 minutes.
Did some of these students come in and go straight in for their interviews while you were sitting?
Yes,
But you waited.
yes.
Did you eventually get interviewed?
Yes, I did.
Who were some of the persons who interviewed you?
There were 3 people. I was interviewed by an admissions counselor, the assistant registrar, and the registrar.
And how long were you in there?
I think it was about 45 minutes.
Do you recall some of the questions that were asked of you and some of the responses you gave?
Yes, I do.
Did they ask you why you wanted to attend the University of Georgia?
Yes, and I told them that the main reason was that it would be more convenient for me to go to school closer to home. Also, because I wanted to write to be a writer. And at present, I had a position on an Atlanta newspaper, and it would just be much easier for me to work there if I were in Georgia.
Did they ask you anything about transferring schools in the middle of the term?
Yes. And I told them that I met with my instructors at Wayne State, and they agreed that if I were admitted into Georgia, I could take my examinations and finish the course early.
Was there anything else they were concerned about?
They wanted to know about my social situations. I told them that I'd had many dates at Wayne State and that I was affiliated with several organizations. They also asked if I attended many parties.
Did they ask you about your family life?
Yes, and I told them that my father was a chaplain and a major in the U.S. Army, and that my mother was a secretary for Wilson Realty Company in Atlanta.
Did they ask you anything about possibly staying at Wayne State?
Yes, they did. They wanted to know that if the economic factors for my reasons in wanting to go to Georgia were excluded, if I would prefer to stay at Wayne State, and if I did, then I could receive some type of monetary supplement.
And what was your response to that?
That I would still prefer to be closer to home.
Did they ask you anything about how it would be making an adjustment to attend the University of Georgia?
Yes. The registrar wanted to know if I expected any difficulty or any trouble when adjusting.
And how did you respond?
I told them that it would be just like any other university after a certain amount of time, and that I didn't expect any trouble from any university students, faculty, or anyone else on campus.
Now, have your feelings in that regard at all changed?
No, they haven't.
Do you have an application pending at the University of Georgia?
Yes, I have.
Have you received an acceptance letter?
No.
Ms. Hunter, did you go to high school with Hamilton Holmes?
Yes, I did.
Were you in the same class?
Yes, we were.
Did you graduate the same year?
Yes, we did.
Do you know, who was the valedictorian of your senior class?
Hamilton Holmes.
Do you know who was listed as the best all-around student at Turner High the year you graduated?
That was also Hamilton Holmes.
Ms. Hunter, did you hold an office in the Honor Society of your high school?
Yes, I did. I finished third in my class at Turner. I was also editor of the school newspaper, and I was voted Miss Turner High.
Thank you.
Thank you, counsel. Any cross-examination of this witness?
Yes, Your Honor, thank you. Ms. Hunter, you said you filed your application in July of 1959, is that correct?
Yes.
I'm going to show you what's already been marked as Plaintiff's Exhibit 15. Is this a copy of your application?
Yes, it is.
Thank you, Ms. Hunter. Now, after you applied to the university, you received notice from the university registrar that the university was full, did you not?
Yes, I received a letter stating that due to limited dormitory space, they would not be able to consider my application at that time. Apparently, there were no available facilities.
And you understood as a female student that you would be required to live on campus?
Yes, I did.
Now, after you received the letter from the university registrar, you enrolled in Wayne State University in Detroit, Michigan, did you not?
Yes, that's right.
But you did have the opportunity to come back down to the university in December of 1959, I believe you said.
Yes, but I was unable to get an interview at that time.
But Ms. Hunter, you did eventually get your interview with not one, but 3 university admissions officials, did you not?
Yes.
Now, during that course of the interview, did they treat you courteously?
Yes.
Did they ever ask you anything that embarrassed you in any way?
No.
And just one final question, Ms. Hunter. You can still return to Wayne State University, can't you?
Yes, I can.
Nothing further, Your Honor. Thank you.
Okay, thank you, counsel. Any redirect?
One brief question, Your Honor.
That's fine, counsel. Go ahead.
Ms. Hunter, can you take a course in Georgia history at Wayne State, as is required for those seeking to earn a journalism degree at the University of Georgia?
No, I cannot.
That's all. Thank you.
Very good, counsel. Is that the plaintiff's case?
Your Honor, that's the plaintiff's case. However, we would like to submit into evidence at this time admissions files and records which are relevant to this case and which give the court some sort of accurate comparison to gauge Ms. Hunter and Mr. Holmes against their competition here at the university, Your Honor.
All right, now that's a set of files that I have at my right hand, and you previously submitted those, and I believe the purpose was, counsel, as you've just stated, for the court to compare the admitted students with the records of Holmes and Hunter.
Yes, Your Honor.
Very good. Those are received in evidence, and the court has given them some scrutiny already.
Thank you, Your Honor.
All right, very good. Anything from the state?
Your Honor, we're going to stand on the files which we've already submitted to this court, but first being the file of Mr. Hamilton Holmes, which we would like to present to you at this time. And also, Your Honor, the housing records of the University of Georgia showing that when Charlene Hunter applied, there was a full house in 1960.
And this is the housing office record to show the university was filled up on women's housing?
That's correct, Your Honor.
Very good. Those items are received in evidence. Anything further from the state?
No, Your Honor.
All right. Counsel, with the evidence being closed, are we ready for closing argument?
Ready for the state, Your Honor.
Ready for the plaintiffs?
Ready for the plaintiffs, Your Honor. We will go last.
You're going to go after the state?
Yes, Your Honor.
That's fine. All right, let's hear the state sum the case up. Proceed.
May it please the court, Your Honor, the University of Georgia is an honorable institution. For 175 years, the University of Georgia has been producing governors, senators, and leaders in communities throughout our state. We have literally molded boys into men and girls into women. And to continue this great legacy, the University of Georgia will only accept the best and the brightest. Your Honor, this is not a case about race or color. It's about resources and qualifications. There are numerous instances of people applying to the university and being denied because they didn't meet the basic qualifications for admission. Others had the misfortune of applying at a time when resources simply weren't available. I don't need to tell you this, Your Honor, but the University of Georgia is a state school, a public school, paid for by state tax dollars. And as a result, there are limited resources. Everyone who applies can't get in. And that's what happened to Charlene Hunter. Your Honor, Charlene Hunter is a good student. Unfortunately, she applied at a time when facilities were tight in the fall quarter of 1960. As soon as resources are available, she'll be admitted to the university. Now, Mr. Holmes is an entirely different story. Mr. Holmes was denied admission because of all the lies and deceptions on his part. You saw it yourself, Your Honor. Mr. Holmes was granted an interview with University of Georgia officials, and in that interview, he was asked, "Do you have an arrest record?" And at no point during that interview did he disclose that he had a traffic violation. Yet in the files that I've submitted to this court, you can see that he has this citation on his record. Mr. Holmes is not only a lawbreaker, he is a liar and does not meet the qualifications for admission to the University of Georgia, and therefore his claim should be denied. Now, I've commented on the conduct of the plaintiffs in this case. At this time, I'd like to turn to a very different topic, Your Honor, that being the conduct of the plaintiff's counsel. During the course of this hearing, he has made up all sorts of rationalizations and excuses for the plaintiff's conduct. While some may call the plaintiff's counsel a foot soldier for justice, I would call him a foot soldier for the NAACP.
Objection, Your Honor. That's improper argument.
Exactly so. Counsel, the motivations and associations of the plaintiff's attorney have no place in this courtroom. Move to another line of argument. Sustained.
Thank you, Your Honor.
All right, Your Honor. Please. Please do not hold a great institution hostage to special interest groups and outside agitators who want to promote a few specially selected candidates. Test cases. Let me be clear. If we don't stop Holmes and Hunter in their tracks right here, right now, more cases are going to be brought down here to Athens, and we're going to see a continuation of the same types of violence, the same types of disorder, the same types of chaos, which is currently plaguing our campus. Rocks are being thrown. Windows are being broken, all as a result of the agitation caused by this case. In conclusion, Your Honor, it's readily apparent why we're here today. We are here today because of race, but not because the University of Georgia practices racism. We are here because a few individuals want to come down here and stir up a whole bunch of trouble. They want to tear down this great institution and everything it stands for. Your Honor, you cannot allow this to happen. Now is not the time. Mr. Holmes will never attend the University of Georgia. As for Ms. Charlene Hunter, she just needs to be patient and wait her time. Thank you, Your Honor.
All right, counsel, we have the remarks in the record for the state. Let's hear the plaintiff's closing.
Your Honor, we've previously submitted to the court files and records from the University Admissions Office which are relevant to this case. I'm sure Your Honor has had a chance to look them over.
I have. They've been very helpful to this court in making a determination, counsel, and I appreciate you flagging those to my attention again.
Thank you, Your Honor. May it please the court. 10 years ago, the first black applicant applied to the University of Georgia. He was denied admission because he came from what they said was a non-accredited institution, Morehouse College, which received an A rating by the Southern Association of Colleges and Secondary Schools. Being denied, he filed suit in this court based on discrimination against his race and his color. In 175 years, only 3 other Negro applicants have applied, 2 of which sit at counsel table, Mr. Hamilton E. Holmes and Ms. Charlene Hunter. None of them have been admitted. The issue before this court is whether UGA discriminated against the plaintiffs based on their race and their color. The University of Georgia says that there are 2 reasons why they denied the plaintiff's admission. The first of which, Mr. Holmes' case, they claim is a lack of qualifications. The second of which is simply a lack of facilities. None of those reasons are true. We reject and we resent the character attacks on Mr. Holmes today by opposing counsel. Those attacks began in the admissions office with those records and the interviews, and they continued unabated throughout this trial. These attacks, too, are simply untrue. Mr. Holmes was and still remains an outstanding student. Mr. Holmes graduated valedictorian from his high school, Turner High School, a Negro high school. Mr. Holmes was also best all-around student. He was co-captain of the football and the basketball teams. Mr. Holmes comes from an outstanding family. While at Turner High School, Mr. Holmes received 36 A's and 6 B's. Mr. Holmes desires to pursue doctor as his profession. And so he decided to pursue that goal at Morehouse College for a year. But at that time, more than a year ago, he decided that it would be best to apply, attend, and graduate from the University of Georgia. Now to Ms. Hunter. Ms. Hunter graduated 3rd in her class from Turner High School. Same high school as Mr. Holmes. While at Turner, Ms. Hunter was editor-in-chief of the school newspaper. She desires to pursue journalism as a profession. Ms. Hunter, pursuing that goal, was forced to attend Wayne State University, all the way up north in Detroit, Michigan. Both Mr. Holmes and Ms. Hunter were unfairly and unjustly denied admission. This was not about their qualifications or their aspirations. This was not about their character. This was about the color of their skin. And it's time for the University of Georgia to change. It's time for the University of Georgia to grow and to accept all of those, regardless of the color of their skin, based on their qualifications and not their color. What happened to Horace Ward will never happen again. Thank you.
Thank you, counsel. Parties, the court having heard the evidence and the arguments, it's now time to rule, to enter a ruling on this case. Now, the basic law applicable here is that any citizen of the state of Georgia applying for admission as a student to any public college or university of the state, if otherwise qualified, cannot be denied admission solely because of race or color. That's the basic legal proposition at issue here. This case presents precisely that issue for decision. Plaintiff Hunter was denied admission for the fall quarter of 1960 due purportedly to limited facilities. And the regulation at that time was female students under 23 years of age must be housed on campus. Also cited by the state was a shortage of laboratory facilities. However, the court notes in looking through these files that several applicants were accepted for admission, notwithstanding that claim of loaded facilities, after the date that Charlene Hunter applied. Further, we found one very interesting thing with the assistance of counsel in one of these application files. There is a note from the chancellor of the university system, a note to the president of the University of Georgia. And I'm going to quote that note right now. It's part of the record in this case. The chancellor said, I quote, "I told a member of the Board of Regents that all the dormitories for women are filled for the coming year. And I know you as president are relying on this to bar the admission of a Negro woman from Atlanta." Now, Plaintiff Holmes was barred on the basis of his interview. This personal interview requirement for applicants was imposed by the Board of Regents beginning February 11, 1959. That's when this interview requirement came into being. Yet a review of these same files indicates to us that some students were accepted for the winter quarter of 1960 with no record of an interview. Contrast that loose application of this interview requirement to the way it was applied to Mr. Holmes. 3 university officials interrogated him for an hour with questions about houses of prostitution and red light districts. The record also discloses that in his file, on the interview sheet, one of the interviewers put this notation: "Student was evasive with his answers. Some doubt as to his truthfulness." We note, the court notes, that the application of Horace Ward years earlier was rejected because he too was judged to be evasive and his answers contradictory. Almost the same thing said about Mr. Holmes in this case. Accordingly, this court finds that while there is no written university rule excluding blacks, there is a tacit policy which excludes students based on their race and color. This is unconstitutional. Now, those are my findings on the main case, but there are 2 additional considerations the court needs to treat at this moment. There is talk about closing the university if the court admits these 2 students. As a matter of fact, there's a Georgia statute, the General Appropriation Act of 1956, which unequivocally calls for a cutoff of funds from the legislature in the event a black person enters a formerly all-white institution, quote, whether as a result of voluntary action by the institution or by involuntary action, such as a court order. The legislature has further declared that schools shall be open to citizens of the state, but again I quote, separate schools shall be provided for the white and colored races. The governor of Georgia has gone public on this and has issued a public statement within the last 2 days saying he will be required to cut off all funds to the University of Georgia in the event of the admission of these 2 students. Now, if the funds of the university are cut off, it will cause irreparable damage to the students, the faculty, to the institution. And so this court has to deal with that issue as part of this case. It is hereby ordered that the governor, the assistant director of the Bureau of the Budget, and all persons in active concert with them are hereby restrained from cutting off funds which were previously or are hereafter apportioned to the University of Georgia. Now, I mentioned there were 2 issues. One is the cutoff of funds, and I've dealt with that. The second is the subject of mob violence. I believe one of the counsel mentioned that in his speech, and the court's aware that demonstrations surrounding the entry of these students have become violent. Bottles and bricks have been thrown. The court has learned that last night here in Athens, 4 men were apprehended. These were non-students as they were loading rifles into the trunk of a car. In the case of one particularly vigorous protest, Athens police had to lob tear gas into the crowd. Now, some see this as a reason for this court not to proceed. The view of this court is quite different. Constitutional rights are not to be sacrificed in the face of disorder, nor can lawful orders of this court be frustrated by mob violence. Nothing in these demonstrations shall slow the work of this court. Accordingly, it is first the finding of this court that Hamilton Holmes and Charlene Hunter would already have been admitted to the university if they'd been judged on their merits and not their race. That's my finding. And now my order. It's the order of this court that they be immediately admitted to the University of Georgia. So ordered. Ladies and gentlemen, before I get to my favorite part of the program, which is introducing the law players, I need to mention that while the transcripts of the trial of this case were available to us, and we made good use of those, the record of the closing arguments was not. Accordingly, we prepared the arguments today, the summations by counsel, from the known positions of the parties in the case and in a manner consistent with the historical record of the times. Now I want to introduce you to some young people I'm very proud of. This crew sometimes is called the Mighty Carlson Law Players, and I'd ask you to hold your applause until I introduce all of them. First, attorneys for the state, David Ballard, Eric Chambers. Attorneys for the plaintiff, Chad Mance, Alex Shalishali. Our witnesses today were Chris Bruce, Sharita Jones, our bailiff, Parker Morgan, and our casting coordinator, Megan Callier. Folks, round of applause for the law players. I'm going to ask our panelists to come forward right now, and as I do, it's my privilege to introduce Professor Lonnie Brown, our moderator of the panel. Professor Brown teaches courses in civil procedure, legal profession, conflict of laws. Lonnie's research concentrates primarily on legal ethics and the adversary system. He examines the litigator's duty as officer of the court and zealous client advocate. In addition, he is the A. Gus Cleveland Chair of Legal Ethics and Professionalism. Professor Brown earned his JD degree from Vanderbilt and his bachelor's degree from Emory University. And now, Lonnie Brown.
Thank you, Professor Carlson. First, I want to say it's an honor and a privilege to be a part of such an outstanding program. And I like the fact, I'm proud of the fact that we were able to showcase what wonderful law students we have here at the law school. Before introducing our distinguished panel to you, I want to recognize a few very special guests that we are honored to have with us today. First, and I'd ask that they stand as I call out their names. First, we have with us Mrs. Hamilton Holmes, who is the widow of Dr. Holmes. Ms. Holmes, if you would stand. We also have Miss Allison Holmes Johnson, who's Dr. Holmes' daughter. Miss Ann Boodle Hall, who's Judge Boodle's daughter. Mr. John Ellsworth Hall III, who is Judge Boodle's son-in-law, and Ms. Hall's husband. And last, we have their son, Mr. John Ellsworth Hall IV, who I want to add is a 1997 graduate of the law school. Now for our distinguished panelists. First, we have, being seated right now, the real Judge Ward. Mr. Mance did an excellent job, but you can't replace the real deal. Judge Ward, a native of LaGrange, Georgia, received his bachelor's degree in history with honors from Morehouse College in 1949 and his master's in political science from Atlanta University in 1950. In that same year, as you've heard, he applied to the University of Georgia School of Law, making him the first African American to seek admission to the university. His application was denied, and he subsequently sued in the very federal court on which he now serves in an effort to have the law school's decision overturned. Unfortunately, his legal battle was ultimately unsuccessful, but he courageously set the stage for Charlene Hunter Gault and Hamilton Holmes, and as you saw in the reenactment, served as their counsel in the case, along with renowned civil rights attorneys Donald Hollowell and Constance Baker Motley. Judge Ward received his law degree from Northwestern, and after a brief stint as a claims agent with the Social Security Administration in Chicago, he returned to Atlanta to practice law with what would eventually become the firm of Hollowell, Ward, Moore, and Alexander. Judge Ward also served for 9 years in the Georgia Senate, and in 1974, he became Georgia's first African-American state trial court judge, having been appointed by Governor Jimmy Carter to what was then known as the Fulton County Civil Court. 2 years later, he was named to the Fulton County Superior Court, and in 1979, President Jimmy Carter appointed him to the U.S. District Court for the Northern District of Georgia, making him the state's first African-American federal judge. Judge Ward currently continues to serve as a senior judge for the Northern District. Next, we have Justice Robert Benham. Justice Benham is also a native Georgian, growing up in Cartersville, Georgia. He attended Tuskegee University in Alabama for college and earned a bachelor's degree in political science. After graduating from Tuskegee in 1967, Justice Benham became the second African American to enter UGA's law school, Chester Davenport having been the first in 1963, and Justice Benham received his JD in 1970. After completing law school, Justice Benham served in the U.S. Army Reserve, attaining the rank of captain, and then practiced law briefly as a trial attorney with the Atlanta Legal Aid Society before returning to his hometown of Cartersville, where he became the first African American to establish a law practice. In 1984, Justice Benham achieved another first when he was appointed to the Georgia Court of Appeals, and yet another just 5 years later when he was elevated to the Supreme Court of Georgia. In 1995, Justice Benham made history once again when he was chosen as the court's Chief Justice, and he served in that capacity for the next 6 years. Justice Benham remains an active member of the court. Next, we have Kenneth Dyess. Mr. Dious is a native of Athens and also a trailblazer in a number of respects. After attending Savannah State College for a year on a basketball scholarship, he transferred to UGA and was one of only 7 African-American students at UGA at that time. At UGA, he excelled in the classroom and between the hedges as the first African-American member of the football team and, I understand, the first African-American to play football in the entire SEC. Mr. Dious graduated with a degree in business and finance, and 2 years later entered the law school, graduating in 1973. After beginning his legal career as an attorney with the NAACP Legal Defense Fund in New York, Mr. Dious returned home to become Athens' first African-American lawyer. He opened his own law practice, which he has maintained ever since. Our final panelist is Miss Maureen Downey. Ms. Downey is a longtime reporter for the Atlanta Journal and Constitution, who over the past 12 years has written about local, state, and federal education policy and currently maintains a popular education blog known as Get Schooled. In addition to her time with the AJC, she has also worked for newspapers in both New Jersey and Florida and has taught college classes in mass communication and journalism. Ms. Downey received her undergraduate degree from the University of Delaware and a master's degree from Columbia University. I think that it's only fitting that we begin our discussion with Judge Ward, without whom we very well might not be celebrating the 50th anniversary of desegregation at UGA. Chapter 5 of Dean Maurice Daniels' excellent biography on Judge Ward is appropriately titled Ward's Cause Reenacted, the Applications of Charlene Hunter and Hamilton Holmes to the University of Georgia. I don't think that it's an exaggeration to say that our reenactment today would likely not have had such a favorable outcome if Judge Ward had not first courageously pursued his 7-year legal battle with the university. Now, in light of your disappointing and unfortunately unsuccessful attempt to gain admission to the law school, Judge Ward, what was it like for you to advocate on behalf of Hamilton Holmes and Charlene Hunter Gault in their efforts to gain admission?
Well, it was a step forward in my career. I was a young lawyer, joined the Hollowell law firm in 1960, and the case was pending at that time before Judge Boodle in Macon. So Hollowell added me to the list of lawyers for the plaintiff. It was Hollowell and Constance Baker Motley. So it was, in a sense, I say it was vindication of my efforts some 10 years earlier to try to get into the University of Georgia Law School. And kind of set me on a career of being a trial lawyer and also being a so-called civil rights lawyer in the state of Georgia.
What was your reaction to Judge Boodle's decision in the case? You recall how you felt when Judge Boodle announced his decision?
No. The case was tried right here in Athens. This is the Middle District of Georgia, tried here in Athens, and we drove down each day from Atlanta. Hollowell, Vernon Jordan, Constance Baker Motley, Charlene Hunter, Hamilton Holmes' mother. And Judge Boodle was a no-nonsense judge. After we finished the trial in late December, he gave us a few days in middle December, gave us a few days to write closing briefs. And Don Hollowell and I went to New York, consult with Miss Motley, and we wrote the briefs and filed them. But on the 6th of January, he issued an order that was somewhat of a surprise to me, that Charlene Hunter and Hamilton Holmes would have to be immediately admitted to the University of Georgia. So he was the first federal judge in Georgia to rule to desegregate higher education in Georgia.
Now, I'm guessing, actually no, but I'm just going to say I'm guessing, that after the opinion, the university did, and the government did not embrace desegregation. I mean, it was very historic for Judge Boodle to have entered his order, but can you describe a little bit about the aftermath of the decision?
Yes, I was a little afraid for Hamilton Holmes and Charlene Hunter to come down here so quickly, but they decided they wanted to go right away. So Vernon and I, along with Tup Holmes and Charlene's mother, drove down here, and I escorted Hamilton Holmes to his school, and Vernon escorted Charlene Hunter to her school. And it was very tense. Later on that day, Attorney General Eugene Cook and the defense team went to Macon, and they surprisingly got Judge Boodle to change his mind. And he issued a stay of the execution. So they kicked us off the campus, and we went downtown and waited. But later on that day, at nighttime, Judge Tuttle had vacated the stay. So they came back, and Charlene Hunter and Hamilton Holmes was kicked out after a riot after Georgia lost, I believe, a basketball game to Georgia Tech. And they went home, and of course, Judge Boodle ordered them back in.
I think Judge Ward made reference to Vernon, and that's Vernon Jordan. I think it's important to note that Vernon Jordan was a very recent law school graduate and was serving as a law clerk for the Hollowell firm at the time, and was responsible for uncovering some of the critical documents that led to the ultimate decision in the case. Justice Benham, I think you were probably a little teenager at the time of this decision. Do you have any recollection of what was going on down here in Athens in connection with this decision?
I do have some recollection. I think it was about 13 or 14 at the time. I had been to Athens before, but my parents talked about it a lot. My parents referenced the fact of the Ford Creek murder that had taken place in Walton County the same year I was born. And my parents were concerned about this area of the state at the time. In fact, my dad had been offered a job as the district manager of an African-American insurance company here in Athens and declined it at the time. So we talked about, at least this was in an era when children were not allowed to talk, so we listened as my parents talked about it, and my dad had appeared before the Sibley Commission, and the Sibley Commission had started to have hearings about integrating schools, what would happen. And we listened to that conversation because a conscious decision was made for my daddy to go before the commission, because he was one of the few people in town who did not work for white folk, so would not lose his job if he testified before the Sibley Commission. And they talked about what this would mean and what effect it would have. And my mom and dad said that they knew that this day was coming, and it should have come much sooner. So we were aware of what was going on. It was talked about in the community, covered very little in the press. But my dad made a comment back then. He said, this kind of discrimination could not take place in isolation. In order for it to happen, you must have some official involvement. and he talked about how the legislature had passed a law saying that they would cut off the funds and everything. So my dad believed that if people had a chance to work with each other, they could work out some things, but sometimes government interfered and made it difficult for them to do so.
Now, as a Supreme Court justice, you've seen a lot of lawyers come before you as a Court of Appeals judge, and you yourself were an active trial lawyer. What's your impression of the lawyers, the reputations of the lawyers involved in the case? And Judge Ward's to your left and very close to you, so you need to be careful commenting on him.
Of course, I've known Judge Ward over a period of time and actually tried cases before Judge Ward when I was a trial lawyer. And he and I have known each other for a long time, and I also tried cases before Judge Tuttle. And actually, when you talk about the caliber of lawyer, you had some very, very talented lawyers trying the case on both sides. And I've always said that good lawyers can argue both sides of the case, and good lawyers have a responsibility to represent their clients, whether they embrace their client's position or not. That's the role that a lawyer plays. And I looked back, and I was particularly interested in some of the lawyers. One of the lawyers who represented the state in opposing the integration was also a lawyer who headed up part of my campaign committee to be elected to the Court of Appeals. And of course, I was over to his house for dinner and things like that. He never told me the role he played in the case, but that's what a lawyer does. That's the role a lawyer has. A lawyer has to represent a client, but he does not have to embrace that client's political view or that client's social view. That's the role of a lawyer. So I applaud the lawyers for the role they played in this case on both sides, on the plaintiff sides and the defendant side. I think they were very able and capable lawyers.
Mr. Dious, you were here in town at the time of that decision, so can you give us an insider's account of what the atmosphere was like in Athens during the litigation?
As I recall, during the time the litigation was going on, it was not much press in Athens. At that time, primarily what was going on with the citizenry of Athens, they were aware that that case was going on. We were at that time engaged with the Klan. Sit-ins was at that time was coming about. And as a young kid, 14, 15 years old, Justice Benham always said he's the same age I am. I don't understand that, but anyway. We were primarily engaged in that. Did talk, the community was the African-American community was very nervous about it, because if this was to come, then we knew that it was going to create greater confrontation in regard to, this is something that was all new. There was nothing you could base the past on. The marches and the sit-ins, and now here this come. Is this going to mean an all-out racial war? Everybody got to go get their guns. What is going to happen? And a lot of people were very, very nervous. I believe it was about the same time that the Lemuel Penn case was going on, where the Klans had killed Lemuel Penn, who had come from Florida, and the FBI had come to town looking for the person that had killed Lemuel Penn. It was a great case if you're a law student against the United States, because it's and that case was in Athens, was the first case that came out that, if you remember the Rodney King case, it was the case that first said that you could not interfere with the right to travel. But that case had not gone to the Supreme Court yet either. So all this was going on in Athens. You got to remember, at that time the university was smaller than what it is now. And so nobody knew exactly what was going to happen in that regard. So when Charlene Hunter and Hamp showed up, of course the Klan showed up, not as great force as I thought he would, but there was some marching and rioting about the students. Being a kid, 14, 15 years old, of course I'm over here looking on, seeing what's going on, and so forth in regard to that. I remember those things that took place.
What were your impressions of the decision itself? I mean, I assume you were aware of the decision. What was your impression at the time?
As a 14-year-old, 15-year-old kid, I just knew that things were changing. You know, the 60s were coming. At that time, I had no intentions of attending the University of Georgia. Didn't know what this was going to be. At that time, I had not met Don Hollowell or Templeton Holmes or Charlene Hunter, Constable Bateman Markley. I did see, when I was a kid at that time, Constable Bateman Markley and Donald Hollowell did do some sitting cases here. You got arrested for marching, you know, you're breaking the law for trespassing. Remember seeing them getting tried in state court here in Athens. Just knew change was coming, didn't know what the end results were going to be, just caught up in the melee of the moment and just going to push forward.
Did the decision affect your schooling at all? I mean, was there a spillover effect from this decision to integrate the University of Georgia on secondary schools?
It did. Georgia? At that time, you had after that, the Freedom of Choice plan may have been in effect, came about at the same time. And I was in high school when the Freedom of Choice plan came about and chose not to participate in it because I was a football player. And I didn't want to go to the white high school. At that time, I didn't want to deal with that. But there were some black kids that was going over. But I think it came about maybe a year or so after this decision. Yeah.
Ms. Downey, as someone who studies about and writes about education policy, what is your sense of the role that race continues to play in higher education or in education in general?
I think race plays a big role, and I think that the question today is, are segregated classrooms more acceptable today because, as a result of choice rather than court order or law? And what we are seeing in Georgia, we're seeing it nationwide, but we're seeing it actually at a faster clip here in Georgia, is the resegregation of schools by residential housing patterns. And it's very problematic, although you don't see too many folks fretting about it beyond researchers. I mean, people are choosing to live where they live, and it's hard to sort of to argue with that choice. But what's happening is that both white and black parents are retreating from the idea that their kids need to ride across town 45 minutes for a good school. In fact, the issue isn't any more white or black schools, but we need good schools. The problem comes in when you look at the differences in income. And high minority schools often tend to be high poverty schools. And those of you who are teachers, as Ms. Holmes can probably verify, when you have a lot of kids in one classroom dealing with the issues of poverty, housing issues, health issues, unemployment issues, when you have schools that are consolidated in poverty, so a lot of kids have those problems, it gets in the way of learning. So I think we have some serious issues nationwide, but here in Georgia, on the resegregation of our schools and what that means to education. Thurgood Marshall's the guy with all the wonderful quotes about the importance of integrated classrooms, and he understood that it wasn't a magic bullet that white and black students sit alongside each other. The magic bullet was that middle-class parents bring more resources to schools. They bring after-school chess clubs. They bring involved PTAs. They fund sports programs. So the issue to him wasn't so much that we have these kids together to have this rainbow you, but the idea was that you bring to bear the resources of the majority and all kids benefit by that. And I simply don't know if we have any commitment to that ideal any longer.
During her 50th anniversary lecture that hopefully many of you have either seen on the website or were able to see live, Charlene Hunter Galt asserted that the bases for the hostility exhibited towards her and Hamilton Holmes and to desegregation in general were, quote, ignorance and its wicked companion intolerance, end quote. While acknowledging that we as a society have come a long way, she went on to observe that ignorance and intolerance continue to plague us in America and breed unhealthy racial relations. She then challenged her audience to engage in a conversation to come up with concrete ideas to overcome these twin evils, and as she put it, get us on the good foot. So I put to the panelists, and I warned them about this question, what are your thoughts on how we can go about getting on the good foot, as Charlene Hunter-Galt put it? Start with you, Mr. Dyess, since you're closest to me.
Oh. I think she's right about the housing pattern and so forth, and how we're going to resolve that problem. That is really the new frontier in regard to young lawyers and law students out there. How are you going to really resegregate American schools and stay on the good foot in that way? The biggest argument that you always have in regard to public schools is that my daughter want to take chemistry, and I don't want to put a slow kid in the same classroom that slows my daughter or son down from learning at the high rate that they should learn. And how is that going to be resolved with a kid that a father doesn't have a PhD or a law degree, kid coming out of poverty, that how are they going to miss and go to school together? We have not yet figured out a way to solve that problem. Honestly, this country has thrown money at it. They've thrown a lot of programs trying to resolve it. I wish I had the answer in that regard. So it's more of an issue of, to me now, more of an issue of socioeconomics to some extent than it is a race. I think that at this point, this country has grown to the point that it would deal with the acceptance of African Americans, but everybody wants to have a quality education. Everybody wants to go to the quality school, and no one wants to say, I want this kid in my school that's going to bring down the education level. How you solve that problem, if I had the magic answer, I would give it to you. But it's the new frontier.
Ms. Downey?
I absolutely agree that the desegregation of schools by socioeconomics is the new civil rights frontier. I think that's absolutely true. I also think that we're not going to get it by mandatory programs. I think, frankly, all parents are tired of mandatory programs. But I do think that we can be creative. I think one idea is to expand public school choice. Let me emphasize public school choice. I think that we should, the magnet schools and theme schools, in other words, build theme schools and magnet schools that are attractive enough to draw kids from across town. Those of you familiar with DeKalb County will know that they've got a high-achieving magnet named Kittredge School there. And parents in DeKalb will always say that they want neighborhood schools, but most of them, I think, as I might have said in the past, will run their grandmother over to take their kid to Kittredge School because it's a great school, teach German. I mean, there are ways to lure parents, black and white parents both, out of their neighborhoods. But I simply think if we go with the idea that neighborhood schools are best, we will continue to have a great deal of segregation within our school system. So I think that we have to look for voluntary ways to make parents want to sort of mix it up and be willing to take their kids a little farther for a school that may offer a science magnet, a math magnet, performance arts magnets. I think that may be an acceptable way to go to all parents.
Justice Benham?
I don't know if I can just limit my comments to just education. I think education is part of a bigger picture. But I do want to give this country credit for the progress we've made. We have made significant progress in this country. And I think what will bode well for our future is our realization as to how we made this progress. This progress has come about because of our diversity. Everybody doesn't look alike. We don't have the same religion. We don't have the same experiences. But those differences strengthen us as a country. They allow us to win more medals in the Olympics. They allow us to have more patents. They allow us to have a better court system. The differences cause us to be sensitive to the needs of others. So I think we need to work on a realization that our strength comes from our differences. And once we see that as the pattern that we need and one that has helped us, I mean, because we're a country of immigrants. I mean, the only person probably in this room who's not an immigrant probably is one of my former employees here who's a Native American. Everybody else is an immigrant here. And so if the immigration has made us strong, it's the differences that have made us strong. We have to work in appreciating those differences. We have to see that as a roadmap for the future. We have to have, you know, most sociologists have said it's a 5-stage step. Awareness, then consequences. What will happen if we do nothing about it? We're seeing in some areas where nothing is being done about it. And the third stage is the stage in which we are engaged now. That is a normalization of discussion about differences. And you have to have people who have a vested interest in the resolution of the problem, discussing solutions to the problem. That's what we're doing today. Then there needs to be change, and then institutionalization of change. So the roadmap is there. It's a 5-step discussion, and thankfully, we're in the third stage of that discussion.
Judge Ward?
Yes, sir. I agree with Justice Benham that a lot of progress has been made in many different fields. However, many things remain to be done. Of course, I'm 61 years out of college and 51 years out of law school, so I'm one of the old guys around, so I've seen a lot of changes. And I'd like to see some more. What we need is more debate and more dialogue. Of course, we've come a long ways. We got an African-American president, but that doesn't change everything. It changes a lot, but it doesn't change everything. We got a lot of the same problems now that we had before Barack Obama was elected, and we'll probably have some when he's gone. I don't know how long he's going to be there. I hope it's another 4 years, but I'm a federal judge. I can't politic. I agree with much of what Charlene was saying. Back at that time, she was talking about 50 years ago, a lot of ignorance and intolerance. And of course, I've witnessed it along the way, all the way from LaGrange, Georgia, on up through Morehouse College. I had the privilege of attending Morehouse College. I didn't get into the University of Georgia, but I did go through Morehouse College, where I studied, I came under the influence of Dr. Benjamin Elijah Mays, and had the privilege of studying with outstanding students, including Martin Luther King, Jr. Martin Luther King, Jr. finished Morehouse in 1948, and I finished in 1949. So we've seen a lot, and things are looking up, but there's still a lot to be done.
I think that Charlene Hunter-Galt's statement that we need an ongoing conversation was very profound, and I do hope that our program today will serve as a significant reference point for that ongoing conversation. If you'd join me in a round of applause for our very wonderful panel.